Very good morning, everyone. We'll start on time. It's 10:30. Honorable Justice Ravindra Bhat, Vice Chancellor Professor Shyam Menon, our speaker Professor Philipp Dann, Professor MP Singh, all our guests and our students. I know it's been a difficult day because of the restrictions on travel given the measures to combat pollution. But thank you so much for making it despite those restrictions coming in. I am Preetham Barua. I am the Dean of the School of Law at BML Munjal University and also the Acting Dean of the School of Liberal Studies, which we are just starting. And I will be the moderator for this session. This public lecture series is hosted by BML Munjal University. It is a not-for-profit private university under the Haryana Private Universities Act. Our guests today who will be on the dais are Honorable Justice S. Ravindra Bhat, who is Judge of the Supreme Court of India and who will chair the proceedings for today. Our speaker is Professor Philipp Dann, who is Chair Professor of Public Law at Humboldt University, Berlin, and we will have a welcome address by Professor Shyam Menon, who is Vice Chancellor of BML Munjal University, and I'll be giving a short introduction to the lecture series. So I would kindly invite our guests, Justice Bhat, Professor Dann, and Professor Menon to take the seat on the dais, please. With the permission of the Chair, Justice Bhat, I would like to first invite Professor Shyam Menon, Vice Chancellor of BML Munjal University, to deliver a welcome address. May I?
Mr. Justice Ravindra Bhat, Professor Dann, Dean Professor Barua, distinguished guests, my colleagues, my dear students, ladies and gentlemen. It gives me immense pleasure to welcome you to the first Constitutional Sculptures lecture by Professor Philipp Dann. The lecture series has been organized by the School of Law of the BML Munjal University, or BMU, as a part of our endeavor to assume the university's legitimate role of thought leadership in our society and nation. We at BMU have made a conscious decision that this series of lectures should be conducted not on our campus, but in a public venue centrally located in the nation's capital. The India International Center, the venue of this lecture this morning, has over the decades become symbolically the central space for liberal, progressive discourses in the intellectual and cultural domain of India's civil society. Thus, this lecture series is BMU's tribute to the city of Delhi and a contribution to its intellectual life. I congratulate the School of Law and the team led by Dean Professor Barua for coming up with the theme Constitutional Cultures for this lecture series. Although an old civilization, India is still a young nation. The Republic has just turned 70 a couple of years ago, a short span of time in the lives of nations. We as a nation and society pass off and on through turbulences in our political and social lives, especially in such difficult times. It is the Constitution and the values it enshrines that keep us on our course towards our chosen destiny. We realize the importance of institutions of law and justice and the community of professionals who populate these institutions in guiding and assisting us as society and nation to stay the course of realizing the vision of our freedom struggle. The purpose of establishing the School of Law at BMU is essentially to be a nursery of creating and nurturing a community of legal professionals who are constitutionally rooted, scientifically minded, and socially sensitive. The mission associated with our School of Law is not merely professional preparation of lawyers, but also research and advocacy of constitutional values. The Center for Constitutional Values that we have established is essentially the vehicle through which we seek to pursue a part of our research and advocacy goals. Building constitutional resilience, as Professor Dann would argue in his lecture, through legal education does not require wholesome indoctrination of students into constitutional values. wholesale indoctrination of students into constitutional values. Rather, constitutionalism requires that they gain the necessary critical tools to ask questions and reason well. Constitutionalism, even in its most formal sense, requires putting limits on power. Legal education must build the required skills and knowledge base for this. Asking questions and reasoning well constitute the central theme of the curricular processes at BMU. Experiential learning is a central pillar in the edifice of our cultural and pedagogic philosophy. The legal education that we provide at our School of Law is essentially built around this central pillar. It is heartening, therefore, that the first in our Constitutional Cultures lecture series is one that focuses on legal education. We are grateful to Professor Philipp Dann for agreeing to deliver this. We are also grateful to Justice Ravindra Bhat for agreeing to chair this session this morning. Thank you, sir. Once again, ladies and gentlemen, welcome to the first Constitutional Cultures lecture of BMU. Thank you.
Thank you, Professor Menon. The Constitutional Cultures lecture series, as Professor Menon said, is a public lecture series that is a part of the initiatives of the Center for Constitutional Values, and this "for" is important for us. Unlike several academic centers which are on certain topics where we don't want to take a position, in the Center for Constitutional Values, we actively seek to advocate an understanding of constitutional values in the Indian Constitution amongst the public. Its objective is to promote and produce knowledge about a constitutional way of life, where we accept that there are values applicable to humans and also to other beings that are sources of justificatory reasons for political decisions, where institutional distance is maintained from any comprehensive way of life that pro tanto prioritized some individuals or communities over others. And finally, where exercise of political power would be restrained based on the values that were articulated by the law of each community and procedures of fairness. So that's the basis on which the center is being founded. Now, I request the chair for our proceedings today, Justice Ravindra Bhat, to give us some introductory remarks on the topic. And though he needs no introduction, for those who are not from the field of law, a brief introduction may be in order. Justice Shripati Ravindra Bhat is an alumnus of the 1982 batch of Campus Law Center, University of Delhi, and after completing his LLB, Justice Bhat began practicing law before the Delhi High Court and Supreme Court and various other forums. During his tenure as a judge, Justice Bhat is renowned for several landmark judgments, especially in the areas of intellectual property rights and constitutional law, though in his practice, the primary focus has been in public law, banking, education, labor and service, and indirect taxation. There is lots to say about Justice Bhat, but one could find out publicly about it. We are so grateful that you have agreed to join us today, Justice Bhat, and maybe we can start the proceedings with your permission with some opening remarks from you about the topic.
Thank you, Professor Barua. I find it difficult to get around to saying that because I have known Professor Barua as always Preetham, Dr. Menon, Professor Dan, and my distinguished audience, and I must not forget to mention my teacher, who has also been a teacher of Professor Barua, Professor M.P. Singh, who has been a great influence on constitutional law, constitutionalism, and the way we see that document. I'm really very happy that you have conceived of both the Vice Chancellor. You have to be congratulated for conceiving of this public lecture series on inculcating constitutional values in legal education. I think this takes, actually I'm a bit nostalgic because we had amidst us stalwarts who were legal, as legal academics. But what we took out, of course, we were really enriched, but I feel that succeeding generations were not as fortunate. And we had the best from Professor M.P. Singh, then we had Professor Bakshi, Professor Menon, etc. But I think it's what you are trying to achieve through this is something beyond personalities, which is trying to locate the values of constitutionalism in legal education. As I understand it, legal education, the way we were taught and the way rather we saw it, was divorced from the interdisciplinary aspects which is so necessary to understand constitution. Because constitutions have to be understood in the context of the people and the peoples who matter for it. It is not just a legal document. It is not just a law. It is much more than that. It outlines a charter of governance, outlines your liberties, and enriches the content of the citizens' lives. So there is, in a sense, in order to sustain constitutionalism, there has to be a constant movement in society to inculcate its values. And that is where I think that there is centrality to the legal education, and the legal education being part of that as a continuum. Because without that continuum and without making internal sense of the Constitution and how it matters in our daily lives, when you why do we talk of the rule of law? What is the rule of law, and what distinguishes the rule of law? Why do you talk of supremacy of the Constitution? Why do you talk of liberties? In a society as diverse as India, with all its pluralism and multiculturalism, how these liberties matter to individuals. And for that matter, in a country as vast as India, with all its people and different kinds of regions, how federalism is the choice that we took to operate our constitutional system. So I think there is need to iterate this and reiterate this time and again if we have to inculcate this idea of constitutionalism in our society. The building block for this society, for this understanding, has to be lawyers, budding lawyers, law students, who will carry with them. And I believe that they have greater responsibility. They definitely have as much a responsibility as other informed citizens, but perhaps they have a greater responsibility given the way we have chosen our constitution, with the way we have written our constitution. And it's not just a bland constitution, it has a definite slant, that it is people-centric. It strives to a certain value system. We talk of social, economic justice, political justice, etc. And we talk of other concepts like fraternity. So how these are important in daily life. I was just wondering what example can I give at the outset. And it's nothing to do with law, and this is something I just noticed, and it's something struck me right now. I was on a visit to Kerala. Professor Menon, you would resonate with that. I am also a Keralite. Of course, I don't look like one, but I can claim to be a Keralite. So I had been to Kerala, and I was in one of the lakes. So my host was a young man. He was, he was at the steering wheel of a speedboat. So when we were speeding down the lake, he suddenly slowed down and stopped. I asked him, why have you done that? So he said, you see that small boat there? It was it was being paddled by someone. Probably he was taking some produce or goods in that. He said that I have to stop because if these waves go and hit him, he will capsize. Now, I think that brings out the beautiful idea of interrelatedness and how each our actions is bound to react and cause something to the other. The idea of fraternity. So how it informs our daily lives, as I think, perhaps I'm anticipating, as the main lecturer, Professor Dann, is going to speak about indeterminacy of some of these concepts, but at the same, there is indeterminacy. I understand when there's a level of abstraction, perhaps, but when we actually bring it down to real life incidents, we can completely relate to it. So I think I've exceeded my 5-minute limit. again express my gratitude to Professor Menon and Professor Barua and the other organizers for inviting me to chair this session, and I eagerly look forward to the main lecture by Professor Dann. Thank you.
Thank you.
Thank you very much, Justice Bhat, for setting the tone in, I think, both very emotional, institutional, as well as, I think, a way in which we can think about values in our daily lives, which has been the challenge. So thank you for the start. And I must also say that you mentioned a few names. Professor Bakshi has not been able to make it today, but perhaps he's watching. Professor M.P. Singh, we would especially like to thank, because you are the first one to have brought Philipp Dann to to India at NUJS. So we remember those days. So and this connecting of scholars between different countries has really resulted in several collaborative projects such as this, and we are grateful to have Philipp here today. Let me quickly introduce Professor Philipp Dann, who is our speaker today. Professor Dann is the chair professor of public law at Humboldt University, Berlin. His research focuses on comparative constitutional law, law and development, European law, and constitutional law. He leads several collaborative projects with a focus on South-North dialogues, including contestations of the liberal script, the Indo-European Advanced Research Network, legal cultures in India and Europe, and world comparative law. He is also the co-founder of the Law and Development Research Network. Professor Dann's work on comparative law and structures of democracy has brought new perspectives to various interdisciplinary areas of legal research. For example, his recent contribution to understanding the Southern turn in comparative constitutional law in his edited collection, The Global South in Comparative Constitutional Law, which I would encourage everyone to have a look at, brings in a fresh new perspective of how comparative constitutional law is being thought about across the world. He has been a pioneer in projects of what he himself calls slow and authentic comparisons, because comparative constitutional law or comparative law generally is a tricky enterprise by its very nature. But this idea of slow comparison, which many of us have experienced through the leadership given by Philipp, has, I think, really worked, and an example of which is a book on democracy and diversity in India and Europe, which came out through a long exercise of collaborative work between Indian and European scholars. Professor Dann has taught at various Indian law schools, including the National Law School in Bangalore and NUJS in Kolkata. And we at BML Munjal University are also fortunate to have him as an advisor on our International Advisory Board. So with that, we thank him for accepting our invitation, and I now invite Philipp to deliver the first Constitutional Cultures lecture.
Honorable Justice Bhat, Vice Chancellor Menon, dear Professor Singh, dear students, ladies and gentlemen, thank you so much for this invitation and for this very warm welcome here at the India International Center of Delhi. It's really a great honor to speak in this beautiful location that has such a rich tradition of intellectual engagement and debate. I've been here several times before as a guest, and I always admired the location, but also the architecture and the simple atmosphere of this place. So I'm really happy to be here, but also I'm a little bit awed to be invited to speak here today myself. I have to admit that when Professor Barua Pritam asked me to speak about constitutional values and constitutional culture, I was honored, but I was also a little hesitant. To a large extent, constitutional culture and values are local and contextual. And even though I have taught in India several times and cooperated with Indian scholars for many years, I wouldn't want to lecture you about India, nor do I want to bore you about Germany. But then again, I think it is fair to say that India and Germany share a solid basis of constitutional values. These center around an idea of constitutionalism as a particular form of the rule of law based on human dignity, liberty, equality, and collective autonomy. such constitutionalism also rests on organs of the state that protect and promote such values and a political system based on such values. This model is not unique to India and Germany, of course, but became a paradigmatic mode of political life in the 20th century around the world. It is a constitutional way of life, as Professor Barua puts it, that India and Germany and many constitutional democracies around the world share. But unfortunately, we not just share this basis of constitutional values, but also of challenges. Our constitutional way of life has been challenged in Europe as much as in India and around the world. One such challenge, as Professor Barua explained, is political in nature. It arises from those who favor a comprehensive way of life, as Professor Barua puts it, be it religious, cultural, or ethnic. This does not take dignity and liberty of each individual and the collective determination of all as the central framework, but propagate a particular idea of community based on a particular religious, ethnic, or political idea, forced upon all others. Germany, as you well know, has had its fair share of experiences with such approaches throughout the 20th century. Another challenge to the constitutional way of life is more conceptual and runs even deeper. And it has been mentioned by Justice Bhat already. And that is the challenge that may rest in the indeterminacy of values. Dignity and self-determination might sound good as such, but their understanding, their explication, their implementation are contested and always fought over. So how to safeguard the constitutional way of life? How to protect the idea of constitutionalism and perhaps constitutional morality in the face of such challenges and beyond? I want to focus today on the question of legal education, of how legal education might foster or endanger the constitutional way of life. I want to explore with you how legal education can contribute to the meaning and acceptance of constitutionalism among law students, but also surely beyond the legal profession. I develop my thoughts in 3 steps. First, I want to ponder whether legal education actually has any relevance for the protection of the constitutional way of life. I will argue that it might not be the first aspect that comes to mind in this regard, but that there is nonetheless an important, though largely untapped and unexplored potential of legal education to foster constitutionalism and to create what has been called constitutional resilience. This resilience, however, can only be achieved if we take into account the particular nature of law. In a second step, I will therefore try to characterize this nature of law and lawyering in order to find a path to an adequate understanding of teaching law. Teaching law is different than teaching, for example, engineering. And this difference has to be taken into account when thinking about how to organize and how to conduct legal education. Here, I will argue that complexity and the social purpose of law are distinct and relevant characteristics of law that should be reflected. This leads me then, in a third step, to outline 2 models or 2 ideal types of teaching. I will contrast an open plural against a closed instrumental approach to teaching and argue that we have to find ways of teaching in the open and plural mode to promote the constitutional way of life. This, so goes my general argument, will help to instill the respect for constitutionalism and to foster constitutional resilience. This brings me to my first step. Surely you might wonder whether legal education really plays any role in developing and safeguarding constitutionalism and what this role could be. Looking at my home country, Germany, one would say that legal education has had, if at all, an only limited impact. While Germany has been a successful and stable constitutional democracy for the past 70 years, the style of teaching didn't really change that much over those years. It is a style that was, and in many places still is, very much focused on monological presentation of legal doctrine by white male professors. And it is difficult to credit that style of teaching with the success of constitutional democracy in Germany. Instead, I would say that a strong and resilient constitutional culture is rather created and fostered by the content of the constitution and by legal institutions. A well-drafted constitution is necessary that enshrines certain values as much as is an institutional structure that upholds them. Courts are at the very center of creating and sustaining a legal and constitutional culture, as is an effective system of democratic elections and effective governance. In Germany again, in particular, the Federal Constitutional Court in Karlsruhe played an outsized role in formulating basic understandings of constitutional structure and to instill values that then trickled down to lower courts and the state at large. Also, a transparent system of financing political parties and campaigns, a well-regulated system of fair elections and representative democracy ensured regular shifts in power and so contributed to a strong constitutional culture valuing dignity, equality, and as much as collective autonomy. Next to these internal aspects, there are also external ones to the legal constitutional systems. These too should not be neglected in the way they create and safeguard constitutional values. I think, for example, economic success of a polity and the general welfare of people, and hence the feeling by a large majority of the people that the political and constitutional system also works for them, is very important. It's a kind of output legitimacy that protects a constitutional system from disengagement and distrust. One should also not underestimate how important the absence of external aggression or external interferences are, not to speak of war or armed conflict. Those challenges are often not in the hands of the people, but they impact a constitutional culture majorly. At first sight then, legal education, the institutions, the style, the content of teaching law doesn't seem to matter much for creating, shaping, and upholding constitutional culture. But then again, I don't think this is the end of the story or my lecture quite yet. Instead, I argue that there's a link, even though perhaps a rather indirect link, between legal education and the constitutional way of life. You need good lawyers to run institutions and instill respect and a certain understanding of the Constitution and its values in them. You need a legal profession that is able to explain to new generations in new situations, facing new challenges and conflicts, what to expect from the Constitution and what not, and why it is useful to have and to defend these constitutional bases. This hints to the education of lawyers. But what kind of legal education would that be? What approach to teaching, what kind of pedagogy, what kind of institutional and classroom structures would really help to raise such defenders of constitutionalism? To answer these questions, and now turning to my second step, I think we have to first ponder the particular nature of law. As I said before, teaching law is different than teaching engineering. Teaching the laws of women and men is different than teaching the laws of nature. And this difference has to be taken into account. So I come to my second step, and I want to ask what is distinct about the law that we have to take into account to teach law well. I want to point to two dimensions in which the law, I think, is distinct: its complexity and its social purpose. Let's start with complexity. I will mention two aspects of this complexity, but many, many others could surely be added. In the first take, I think there is the double nature of law. Law is an authoritative text, but also a social practice. It has an ideal and a real side. Upendra Bakshi captured this when speaking about the 3 C's in constitutionalism. That stems from the text, the court's judgments, and the social movements. So it's not just the written word, and also not just the constitutional text in the interpretation of the court, but also the social movements and its readings of the Constitution. And it goes even further, this complexity. Law encapsulates an abstract idea, justice, but it's also shaped by the empirical and the complexity of the empirical. The realm of law is shaped by words, interpretations, and heuristic traditions, but it is also shaped by, let's say, the architecture of the court, the dresses of judges, by the political economy that surrounds us. So there's a huge complexity that goes into our understanding and reading of the law. Also, law's complexity follows from its particular dynamic in time as much as in space. Law shall provide stability and stabilize social expectations, but it also must be and is dynamic in that it can adjust to new developments in society, new challenges posed by technologies, new demands. It also has an inter and transnational dimension. It has to take up international developments and integrate them into its structure. Now, next to this complexity, there is a second dimension in which law of men and women are distinct from the laws of nature, and that is their social purpose. Law aims to regulate and order society. It provides the rules for our interactions and ultimately serves our sense of justice. Providing the rules for society means that law is the backbone of the political and the economic system. It has an intrinsic value, playing by rules that apply to everyone, but it also is an instrument. It proclaims and sustains the particular values of a given society, and hence it is political and never neutral. In that way, law is also inherently powerful and political. Law empowers and sorts. It draws lines about what is allowed and what not. It includes, but it also excludes. Hence, the author of the law matters gravely. Given the social purpose of the law, if it aims to be adequate and just, needs to reflect the reality of society. And in the plural societies that are India and Germany, this means that law must take into account this diversity of identities and the plurality of values. So what does all of this mean for teaching law and securing constitutional values and the constitutional way of life? Surely, to acknowledge the complexity of law means that students have to learn that different solutions are possible, that there's not just one definite answer. They need to be flexible in their mind. They have to learn to live with complexity, deal with complexity. Don't always expect simple answers and clear lines. Taking the social purpose of law and its power dimension seriously means that students need to learn that law serves all in a given society, that it must be a limit to power and mindful of the frame of dignity and equality and autonomy as base values of constitutionalism. And all of these aspects have to be reflected, to be honest, with regard to how they play out in the different legal professions that law students will enter into. It is this particular nature of law and lawyering, its complexity and its social purpose, that legal teaching has to address. So how can we educate young minds and old ones to deal with this complexity and this purpose, to instill an understanding of them so that it is appreciated and protected? How do we unleash the widely untapped potential of teaching? This brings me to my third step. I want to address these points by thinking about 4 questions. Who do we teach? What do we teach? How do we teach? And who are we as law teachers? I will try to provide answers to these questions by contrasting 2 ideal types, 2 models of teaching. One that is rather a closed sort of model, and the other that is an open model. I can only sketch these 2 here very, very briefly, but they should indicate the direction in which I'm thinking, and perhaps we can extend them in the discussion. A first question concerns our students and the composition of our student body, and hence the institutional dimension of legal education. Who do we teach and where? Here, one can contrast 2 models. A closed one that builds a certain elite, a cadre perhaps, and against an open one that is broad and plural and inclusive. In the first model, access to education is limited by various factors. It allows or even promotes selection based on loyalty to a comprehensive way of life or to a particular idea about this life. Economic or other barriers, social, geographic, and others, are accepted as long as this ideological coherence, the sort of adherence to the comprehensive way of life, is there. In the second model, the open model, access to law schools aims to mirror the complexity and the purpose of law. Here, the student body aims to be as diverse and plural as society itself. It makes an effort, an active effort, to avoid economic, social, or geographic barriers. It takes into account that if educating students to understand if educating students to understand the complexity and social purpose of law, a plural classroom experience is one important element. And it follows from that for sort of the protection and the safeguarding of the constitutional way of life, such an open plural model seems to be imperative. The second question concerns the substantive dimension, the themes, the fields, the materials of teaching. What do we teach? And here again, one can contrast two models. A closed one that teaches law as if it is somewhat complete and a static set of rules, against one that reflects the complexity and the political nature of law. In order to reach the latter, I would argue that we need a good balance between teaching doctrine, methods, and context. Good lawyering starts, I think, always with a very solid understanding of the law, of the doctrine, of the text of statutes and the constitution, the cases, the interpretations that evolved over them. So basically with the written law. That, I think, is the basis of any good lawyering, and that should not be forgotten. But I think equally important is to train our abilities to understand the law and hence methods. I think we have to put a lot of effort in training students to read carefully, to sort of work with texts, to understand the methods of interpretations, to understand different types of arguments. So I think next to the solid understanding of doctrine, there has to be an equally sort of solid understanding of how to go about the text and the normative documents. But we also have to understand, and this has been mentioned in the earlier speeches, we also have to enable students to understand the context of law. We have to teach them why it is, how it is, who profits and who not. So this means the perspective of other disciplines such as history, economy, anthropology, or political economy to the law are important and should allow students to think and rethink and criticize the law. It is important, if you allow me this pop culture reference, not just to be good in the matrix, but to see the matrix. So with regard to what we teach, I think less is more. It is important to teach students the techniques to deal with the complexity and the overload that everybody of us feels when sort of attempting to solve a normative question. We have to be sort of aiming to rather teach the frameworks over the substance, the approaches rather than the minute details of different kind of legal fields. And then there is the third question of how we teach and hence the pedagogical dimension. When it comes to our style of teaching and classroom interaction, I would again distinguish between a closed model of, I would say, feeding and an open model of enabling. The traditional closed model of feeding is based on monological lecturing from the front. Students take notes and stay mum. They rather sort of pick up and sort of take what they are given by the law teachers, but they are not asked to sort of inquire about the law, interrogate the law, sort of question the law perhaps even. In contrast, an open enabling model aims to be dialogical rather than monological. It brings the students into a conversation about the law, asks them to interrogate and critique it, and make sense of the material that they are dealing with. In fact, it could, in part, let even students teach each other and experiment with models of learning. This can sort of motivate them, and it can also bring in different perspectives that even law teachers don't think about. It can work surely better in small groups than in big ones. So this is another element of where the pedagogical and the institutional dimension kind of connect. that you need. I mean, you probably also need big groups, but in certain senses you have to allow for small groups to engage with the law. Finally, there's the fourth question that turns to us, the law teachers, and hence the composition of the faculty. In the closed model, the selection of faculty mirrors the selection of students. Loyalty to a comprehensive way of life is more important than other aspects. But here too, one can wonder whether the faculty shouldn't be a reflection of society in all its plurality and diversity, just as much as the student body. This would mean that there should be some diversity in terms of gender, backgrounds, political ideas, status. But it's not just about the composition and the diversity of the faculty. It's also about the status of the law teachers, of the faculty members. I think good law teachers, as in those who can teach and reflect the complexity and social purpose of the law, need to be secure. They need to have a certain level of independence, and they need to be professionals in their teaching. They should be true in researching and writing academics as much as practitioners of law. So I think there has to be a good mix to some extent, but I think academic researchers are sort of a very important kind of element of the teaching faculty. Those should be free in their academic pursuits. Academic standards should take precedence over others when composing a good faculty. I come to the end. Legal education, I argued, is perhaps not the first element that comes to mind when thinking about constitutional values and constitutional culture. But once we think about it, we easily recognize the immense potential of legal education to instill a certain habitus, I would say, of respect for the law and produce an understanding for the complexity and the fragility of the constitutional way of life. In my opinion, legal education should aim to convey and prepare for this complexity rather than its substance. It should enable students to deal with pluralism, be socially and politically apt, and be responsible lawyers in all legal professions. Legal education, mindful of constitutional values and the constitutional way of life, acknowledges these complexities of law and recognizes its social purpose and political power. It recognizes that constitutionalism and its values need a constant reformulation and also a critical reappropriation by each section of society and by each new generation. Since law changes, lawyers cannot avoid indeterminacy. They can only be prepared for it with an understanding and respect for the plurality in the framework of the Constitution. Legal education might even, to use a German concept at the very end, instill a sort of constitutional patriotism or constitutional pride that can coexist peacefully next to national, religious, or ethnic pride. Thank you very much for your kind attention.
Thank you very much, Professor Dann, for that excellent and inspiring lecture. I think though Ronald Dworkin said that judges have Herculean tasks before them, Professor Dann has now asked law teachers to complete a Herculean task of getting the complexity of society reflected in law teaching. And I think it's a very interesting way to look at how we teach law every day in our classrooms, because ultimately a lot of the challenges that we perhaps are facing is to address the questions of our plurality and diversity in our classrooms, especially with something as the law, which aims to be objective and give a true answer as if to these questions. So I think it's a good time to think about this. So thank you, Professor Dann. The format we have now is that we have time for question and answers. And after the question and answers, we have a final set of concluding remarks by the chair, Honorable Justice Ravindra Bhat. So I would now open the floor for questions, and Fahad, if we have another mic, we can pass it around. So please feel free to ask any questions that you have to Professor Dann. I would also request you to introduce yourself and then put your question.
Hello, Professor Dan. I'm Pranav Dhawan. I'm quite puzzled by a suggestion that you're making for, which seems to have some degree of inconsistency, in the sense that you, at one end, you are saying that we need a massification of the legal education. It should not be limited to an elite section of society. But at the same time, you're saying we have smaller classrooms, a very resource-intensive way of having interdisciplinary education. So, in a global South context, these two seem to be very challenging to achieve at the same time. You can't, to have a mass-based legal education accessible to a lot of people in this resource-intensive way where you have small classrooms is challenging, and how you think about resolving those challenges.
Shall we take a few questions, or how would you prefer? No, maybe we take 3 questions at a time? Yes.
Hi, my name is Gautam. I practice as a lawyer in Delhi. I have a question in terms of, so when you say that classrooms ought to reflect the complexity of society as one model, I wonder if that's specific to legal education classrooms or law schools, because I think one of the questions that Indian courts are grappling with right now is, the Supreme Court in fact, is what can students be allowed to wear in classrooms in school? And and there was a recent split verdict on that, and one verdict sort of took the view that, you know, classrooms should be uniform spaces where everyone looks the same, and the other view is that, you know, you should. So maybe that question of incorporating constitutional values isn't limited to legal education or law classrooms, but perhaps a wider set of classrooms.
Okay, one more question and then Philip answers.
Thank you, Professor Dan. My name is Ananda. I'm faculty at the law school. So I just wanted to piggyback off of that question, which is, I heard your dichotomy between law of people and law of nature, and how law of people needs to take social context into account, whereas the law of nature, I think unspoken was does not. But there's a whole field of science and technology studies that's saying that, you know, even if you're studying mathematics or physics, you need to be taking social context into account. And I was wondering if you accept that as true, that you do need to take social context into account even for the sciences, does that change anything about your ideal types of law teaching, or does it matter?
So we'll take it in the second round. So 3 questions at a time. So
Yeah, thanks a lot. Prof, thanks a lot for the question about the sort of whether there's an inconsistency between, on the one hand, asking for basically an increase in the number of students, law students, and sort of an increase in the people addressed in legal education on the one hand, and on the other hand, perhaps the idea of teaching in small groups. Yeah, I mean, you're obviously right. I mean, one and the other seem to be at odds at first, but I think there are quite a and then you connected this also to the assumption that perhaps in the global south there might not be the material resources to build more law schools and to have these broader faculties in order to allow for teaching in small groups. Obviously that's true, but it's only, I think, halfway of a sort of an explanation. I think, as we can see, Munjal is a great example. There are private resources that can be mobilized into education generally, but legal education in particular, and not just private resources. I would also always be a supporter very much of public education in general and public legal education in particular. So I think there are resources, but the question is sort of how do you make sure that these resources are spent in a in a coherent and convincing way. And so just scaling up in itself, I think, is not the solution, but it has to be kind of combined with a certain understanding of what is the type of learning experience that we want to achieve. And frankly, I mean, if I look around here in India, there are great examples of new schools of public policy, of legal education and the like, which do exactly that, which actually build interdisciplinary thinking into the teaching of the law at a very early stage. So I think it is, I don't think you can say, oh, we are in the global south and therefore we can't do that. No, on the contrary, perhaps you even have sort of a freedom to experiment and to broaden the variety of experimentation. And also, one doesn't need to go without the other. So I do think that I mean, for example, in Berlin, we have the incoming classes of whatever, 300 people in one classroom. So when I teach constitutional law, there will be 300 people. But they're combined with smaller working groups of 20, which are then taught by younger mentors. And this sort of experience of question of interrogating is possible. Last point on this one, there's also technology. I mean, we all learned in the pandemic how tricky that can be, and that sitting in front of your Zoom screen is not by far equivalent to sitting in a classroom and having the possibility to exchange. But nonetheless, I mean, there are a lot of technological kind of opportunities to bring in more sort of individual focused learning experiences, I think. And I don't think we are at all at the end of exploring those also technological kind of avenues. Okay, now to the second point on by Gautam and you on the question, which I think is a great question, and I have to think about this more, about whether there's a certain sort of inconsistency or whether there's a sort of asking that whether this aim for diversity in the law in the classroom is actually something that is really particular to law school, or should actually apply to every type of learning experiences, and whether there is really a difference between humanities and natural sciences. And I think you're entirely right. I think our sort of learning through STS has shown that we have to sort of bury to some extent the understanding that there is a sort of a mere object nature of natural sciences, of engineering, of how the immaterial world has to be understood, but that there's a lot of sort of human agency in how we understand also engineering. And to that extent, I think you're right. And you could also say that there is a certain kind of political dimension also in natural sciences, and so to some extent also engineering students should be should be aware of what they do when they learn coding or when they develop a nuclear bomb or the like. Entirely given. So perhaps you are right. Perhaps one can extend this, but this doesn't distract from the point that I wanted to make about law school. Because I mean, even though it applies to also, let's say, to schools of engineering, it also applies to law schools. And I think to some extent, at least we in Germany lag behind in this regard. We don't take seriously enough how much this kind of sort of plurality of viewpoints that can be heard in the classroom really matter on how we understand the law. And I would also say, I mean, in Germany we have a public system of legal education, except for one law school which is private. They're all public, so you don't effectively pay for legal education. And so you could say the economic sort of entry points are very low. There are various other points, so that legal education still is very much a certain middle class kind of experience, and the barriers are there. And so I think there has to be proactive efforts to balance this and to bring different viewpoints into the class discussions. But I take your point. It's probably rather similar in teaching humanities, the law, and in teaching engineering. Although perhaps there's a gradual shift. I have to think about this.
We have a few more questions, but I would also encourage if either Justice Bhat or Professor Menon, if you want to say something about any of the questions, please feel free. We are not short of time, so do feel free if you want to comment. And there are more questions, so Professor Hussain and then Lawrence. So.
I am Professor Iqbal Hussain. I am from Jamia Millia Islamia. Sir, so far the teaching of law is concerned, the methodology we use, both Socratic method and case method of Christopher Langdon method. Indeed, when we come to the teaching and the text of the law, we follow two modules, that is the textualism, what is the enactment itself, and the cases. What we find, because I am also trying to attract the attention of Justice Bhat also, what we are finding in nowadays, because in recent past we have seen, so under the banner of constitutional morality, there has been so many transformation, social transformation judgments. For example, same-sex marriage and other issues, that is religious things like that. And even today, there is a dichotomy and inconsistency of the judgment in respect of the termination of pregnancy. Even today, Times of India, there is a news. And age of marriage, conflict of the religious age of marriage, constitutional and the legal age of marriage. Under these circumstances, when you come to the dialogue between the students and the debate, the teachers are feeling which side should we go. So what is your answer?
Shall we take one more?
Thanks. I'm Lawrence Liang, and I teach at the School of Law, Governance and Citizenship at Ambedkar University, Delhi, which Professor Menon was instrumental in starting. As a law teacher, I have a paradoxical impulse, which I also sensed from your talk, and something that I struggle with, which is, on the one hand, the desire to inhabit the domain of the technical, in this case, the doctrinal knowledge, deeper. And at the same time, the desire to escape it by inhabiting the domain of context or transcending that domain. And I see this as being paradoxical for a simple reason, that the question is, how do we do it? And what does it actually mean to rethink, technical knowledge in that sense? The model that we seem to be caught between this domain of the transcendental and the descent is, since Pritham brought Hercules, I can't help but bring in two other Greek mythological characters. It seems to be that we're stuck between the domain of Narcissus, condemned to falling in love with his own image in the lake, which is the problem of deep doctrinal work, right? Which is you fall in love with technicality in a manner that it becomes an end in itself, and you forget the context. On the other hand, when you look at the move away from doctrine and look at, let's say, for example, the intervention of social sciences and the study of law, etc., you move so far away from doctrine that you endlessly repeat abstract normative values at the cost of not being heard, which is the curse of Echo. Echo falls in love with Narcissus but will never be heard by him. So really, in a kind of sense of posing it not so much as a question as much as a dilemma that we all inhabit, how do we actually move between these two realms?
So I think these are two heavy questions. So maybe Philipp answers them first, and then we go to the other questions. Yes.
Well, I mean, yeah, thanks a lot, first of all, to your question, even though I would probably politely sort of ask my neighbor to take over. Because obviously, I mean, in those type of question, I mean, this is like perhaps the best example of where you can't really teach the substance, but you have to enable the students to somehow filter out what is that legal doctrine, precedents, case law has already established. Where do we stand? What's the validity of that, what we stand on? But also be contextual in a way, understand where are sort of new developments in society that sort of you can't ignore, and you can't be a somewhat ignorant originalist and say this cannot come into our thinking. So you have to enable, I think, your students as much as yourself to somehow do a very sort of painstaking, perhaps sort of differentiating and distinguishing kind of exercise in filtering out where you are. And then I think you come to a point, I mean, where you could say one is more a legal question and one is more a political question, if you can call it that way. And then I think you come to a question of separation of powers, which you can perhaps sort of also teach your students, because I would probably be in the more traditional camp to say that courts are sort of in the domain of the law, whereas political questions are more in the domain of the legislator. Of course, this is kind of ideal typically, but I think you can sort of, I mean, you can perhaps try to equip the students to somehow sort of find the layers in these different, in these very hard moral and political issues, and see where they come in with the technique of the lawyer, where they come in as responsible political beings and citizens, and how to navigate the sort of duality or multiplicity actually of roles. Because I think that is the a very important kind of element, to be able to sort of be aware of the plural identities ultimately that you have, and that you be sort of able to adequately deploy your knowledge. And perhaps, Lawrence, I mean, thanks a lot. It's a great observation, and obviously very I can't sort of, it's more an observation than a question, this paradoxical nature. And I entirely see your point, and I also see your point, or I sort of observe myself struggling with these two kind of sort of pulls, not just in legal teaching but also in legal academia. So supervising, for example, PhD students who then research and the like. And there also I find that this kind of narcissist and echo kind of dimension are very present. My answer would probably go into a similar direction. I feel that the different sort of value to me lies in understanding who is my audience and what is the context in which I operate. And sort of when I know, so when I sort of work in the context of a court, obviously I operate with a different set of techniques and have to foreground a different sort of approach than when I sit in the Law and Society Association or the like. And I think to some extent we should be mindful of the sort of particular sort of the distinctness of different contexts and audiences when we do the work, and enable students, coming back to the classroom, enable students to deal with that. I don't want to say that you can sort of neatly sort of separate one and the other, and the overflow is there, and in that sense I would entirely agree with you. It is a paradox, and it is ultimately a dilemma, because you can't really escape it. You have to juggle it. But I think being aware of that dilemma is already a big step forward.
Justice Bhat or Professor Menon, if there's anything to say on the questions.
I have something to.
And I think, yeah, Justice Bhat wanted to say something, please, and then Professor Menon.
I think I'll give a very straightforward answer to what Professor Hussain put to me, which is that if you come across opposing or conflicting points of view, you have the best field, in the sense that if you can distill to the extent one can be objective about this, the principles from each of these views, and then present it to the your audience, so that there is a debate on that, and then let them decide what are the values which are relevant for that context. So that's the way I would view it, because as a judge, and of course sitting as a judge, I'm not at the same time I'm also a student. There's a student within me. So when we do examine conflicting opinions, we have to find out the centrality of the provision, and I suppose that's what law teachers teach, that how faithful you are to the text and the context, and how you have strayed, if at all. So some of these concepts may sound very esoteric, yes, but when you apply them, you'll have to see the context of what the judgments say. And I suppose there is enough robustness in our constitutional principles, or even public law principles, to convey what you wish to convey, and first faithfully allowing them to debate on this. Now, on the other aspect of what Lawrence said, this the narcissist and eco. I think this is one eternal dilemma that I find as a judge, especially the narcissist part, because we get very enamored of technicalities. And what I observe, and this is perhaps a bane of the Indian legal system, is there's perhaps something about the Indian mind itself that we revel in technicalities and complexities, especially on matters of jurisdiction. And you will find that it's a very anecdotal and very broad guess, but then I may not be very wrong. If you analyze the kind of judgments which come out from the court, maybe 20% deal with jurisdiction or some such technicality, where the substance of the dispute is not addressed because of these kind of barriers. So that's the narcissist part. And the eco part is equally there, that we go all around. So I don't know. I would take the Buddhist route and say, let's try and strive for the middle path.
Professor Menon?
No, I have something to say about what you responded, Professor Dan, to Pranav. Pranav, no? Yeah. About this elite versus inclusive thing. And in the response, I got the sense that probably you're saying that there is a dichotomy between the private and the public institutions and so on. So I would like to, what I got from your lecture is actually the fact that having a plural classroom is an essential ingredient of quality. Because what you're saying is that having diversity in the classroom adds to its quality, the quality of discourses that would go in it. So in that sense, even private institutions, rather than regressing to the level of being elite, because and opening it themselves only to people who can afford, I think would actually need to ensure that this diversity and plurality is kept inside, because exclusivity is not quality. That's what I take away from your what you said. So in that sense, I don't see this as a dichotomy. I think we need to really build that, and that becomes a necessity. To Professor Hussein's point, I just wanted to say the following. I'm not a law teacher, but from what I gather from the two law schools I've been associated with, both in Ambedkar as well as in BMU, I can only say that the legal education is about creating professionals not merely to work in institutions of law and justice. They're also to work with legislators. They're also to work for advocacy. They're also to work for formulation of legislations. So if that's the case, then I think we have to really, the doctrine of the given law, the law as it stands today, cannot be the basis. It has to be, I think, as informed citizens, a legal professional will have an additional role to play to ensure that some of these larger social issues are brought into the domain of legislation and becomes law. So I think preparing professionals for that is also our responsibility, I think. So it's so that's how I would look at it.
So we have a few more questions. Anushka here, and then Mihika here, and Alex. So three and both here. Okay.
Don? Yeah. Thank you. I'm Anushka, and I teach at the same center as Lawrence. And in this, very much in the spirit of your talk, we're also invested in the interdisciplinary study of law. But while we do that, there's a danger of looking at law in pursuit of society. And there's a reason why I'm using the word danger, and which is what my question is about. So, like you said, law is to be looked at something which has a social purpose, or the relationship of legal education with, cultivating a certain constitutional culture, going back to Grote, constitutional obedience, etc., etc. Now, we're not just talking about law, but we're also talking about legal education. And education, in that sense, also has to be non-instrumentalist. Needs to be looked at in terms of in non-instrumentalist terms. So, and it's just a dilemma. It's not that I've resolved it. I'm just putting it out. So, to what extent a teleological idea of legal education is beneficial to the study of law in society, and to what extent it can be detrimental, and can there at all be a non-teleological idea of legal education?
So yeah, several questions. So maybe we'll take for Philip. We have time, but we might run out of it. So yeah, Matthew, Mihika, and there was Alex. Sorry.
Thanks, Professor Dan. My name is Matthew John. I teach at the Jindal Global University, and I think my question sort of grows out of Anushka's question, but it speaks to your presentation. Two parts of it. One, a bulk of your presentation was speaking to us about the importance of being able to forensically dissect the social complexity in which law is located, and you ended up with constitutional patriotism. Right. Now, and I think both are important because the ability to dissect also, if you talk of it in the context of constitutional values, it's it's the bridge towards constitutional values, right? And constitutional patriotism fits in somewhere. But given the times that we're located in, how does this commitment to dissecting carefully, right? How does it stand a chance against the more seductive, comprehensive stories that authoritarian populists of our time, seduce us with?
Okay.
Good morning, sir. My name is Meeka. I am a third-year law student at BMU. My question might be it might pivot from what we are discussing today, but while listening to you, what I felt as a student myself is that just pivoting away from legal education, there might be the problem actually might be a bit more deep-rooted, is because when a student is actually in school, they might follow a much more, like what you mentioned, a closed model of education where practices of maybe rote learning is promoted rather than experiential learning. I myself have understood what experiential learning means is when I have come into university. But maybe would you agree to the fact that maybe constitutional values is something that all students, irrespective of them learning laws of nature or laws of men and women, but constitutional values as a whole should be taught to students irrespective of what field they choose in the future. Absolutely. And the fact that rote learning should be discouraged from the very beginning, because this practice is somewhat instilled in the minds of students that you have to absolutely memorize whatever you study.
Maybe we take Alex's question and stop and then come around.
Yeah, Alex Fischer. I also teach at Jindal Global Law School. My question relates sort of to a myth of German constitutional history. So we have this myth that Weimar was such an open, pluralistic, and free constitution that it actually protected its enemies, right? And the enemies used that freedom to sort of wipe that Weimar constitution off the map. And the lesson learned then for the West German constitution is that it's a constitution that can defend itself against its enemies. A good example is political parties were banned immediately after the war. The follow party to the Nazi party was banned, and the Communist Party was banned. And so I think if you compare Germany to France and Italy, you would find very few communist law professors, whereas in France, for instance, it was quite common. So I was wondering legally in Germany, if you are considered by the German authorities a member of such a party, or if you are otherwise under the eyes of the German Verfassungsschutz, which is this organization that fights internal political dissent that is borderline terrorist, you could say, or anti-constitutional maybe not just terrorist. Is there a legal mechanism for removing such law professors, right? Because pluralism, we all agree intuitively it's a wonderful thing. But where do we draw that very difficult boundary of people who bring, I don't even want to call them values, but political preferences into a constitutional law seminar that we might not want to hear, and that might actually be very troubling for some students in a diverse classroom? I'm not sure whether I'm entirely clear, but it's that age-old search for what is the consensus within pluralism that would allow pluralism to function, which is what Ernst Fraenkel, also from Berlin, has done a lot of his work on. Thank you.
Okay, Philipp.
Okay, yeah, the plate is full. I start with Murkas. A question. No, because I think to some extent, I think there my answer is the most straightforward. Yes, I mean, I don't think there's any legitimate place for rote learning as such, but there needs to be sort of the enabling or sort of way of learning that sort of enables you to. I mean, you have to learn something by heart, that's obvious, but then to apply it and to question it and to transfer it to other contexts and the like. And that was one of the main points, right? That there is space and there's institutional capacity to do that and to allow you to do that and to do that actually from an early sort of stage onwards. So because in Germany sometimes you say, okay, first you learn the stuff and then you start questioning it. And I understand also that also from a student perspective, sometimes you want to first get your feet on the ground before you start criticizing and turning over and the like. And I remember that myself very much. But I think we have to find a good way to somehow provide you with solid foundations, but also the instruments to sort of to see where these foundations come from and the like. So in that sense, yeah. Now the second sort of to Anushka. To what extent should there be a teleological idea of education and teleological or non-teleological? Yeah. I mean, I think it's tricky, and I think Alex's last question sort of turns to that. I think, and the starting point of today's event are constitutional values, right? So we don't operate in a vacuum. We don't, I think, as lawyers ever and as political citizens ever operate in a vacuum. And I think one aim, unless you want to be revolutionary, is to operate in that sort of framework of values. So to some extent, but these are, I think, base values, but really like very broad frameworks, and that is actually the point where I want to get at. To some extent, I think there should be sort of in a way, and that's of course also the Humboldtian sort of ideal, perhaps to some extent, to I mean, within that framework, then to provide education that is non-teleological or that is non-instrumental, and that to some extent, sort of, perhaps one can say, is more procedural in a way, in that it enables you to sort of have and develop certain techniques and a variety of techniques, and to be able to sort of change techniques, change perspectives, and work with them. So to some extent, I think one has to strike this balance. I think to some extent one has to be mindful that there is a telos in education, because I think we are sort of social beings. We operate in a certain particular context, and that I would not forego. But beyond that, I think. I mean, what is clear, what would be the opposite, is a more kind of merely instrumental type of education. Yeah, and that leads perhaps to the two questions by Matthew and Alex, which go into a similar direction. Sort of, how does it? You said, sort of, how does it stand up to the challenges of today? This sort of, on the one hand, being dissecting and analytical, perhaps, and on the one hand, perhaps a sort of a patriotism and a pride, and where are the limits? I mean, I think again, I mean, I think it's interesting. It's important to understand sort of in what context you operate, and I think I would probably argue that somehow you will at least be able to distinguish between the scholar and the advocate, and to sort of know what are the instruments that you use and what are the audience in which you, or the context in which you operate between the two, and to be mindful of that. And but that doesn't mean that you can't be sort of and that you shouldn't be actually a strong advocate and sort of involve yourself in advocacy. Quite to the contrary. But I think, I mean, sometimes, especially, for example, in the German constellation, people to some extent misappropriate or misuse their title as professors in making political arguments, and that I think is tricky. And so in that sense I feel one has to be mindful, do you speak as a citizen or more as an expert? I mean, even though again we all know how difficult it is to draw the lines, but I would be sort of always in favor of being very transparent about those different lines. And this goes into your sort of question, sort of to what extent are there boundaries? I mean, the sort of the militant democracy kind of aims, sort of there are sort of limits to the protection of plurality. Yes, I mean, the very concrete question, if I'm a civil servant, as a law professor in Germany, I'm a civil servant. If I would be member of a banned party, then I would lose my job. I mean, that's very simple. And that happened in the 1970s with communists that were teachers, for example. There were no law teachers, surprise, but normal teachers were there. But so you would end there. And I think I'm okay with that. But the last point is sort of how do you ban parties? And that's perhaps I should sort of explain that, because that in Germany only the Constitutional Court can do. And it's a very kind of cumbersome, slow, and sort of multi-step approach before one party or one group is really designated as sort of, as it's called, working to undermine the constitutional order. So it's really only in the sort of, only if the framework, the foundations are in danger, then such a party can be banned. So the framework is broad, let's put it that way.
I know there are a few questions, but we are running out of time, but there is time to continue the conversation afterwards over tea and pastries. I know Vaibhav and Ronak and others had questions. Perhaps we can continue then. But thank you, Philipp, for wonderful lecture and for answering so many of our comments. I would now invite Justice Bhat, the chair of our proceedings, to give his concluding remarks.
Thank you. Thank you again. After hearing the very absorbing lecture by Professor Dan and equally, if not more, absorbing interaction, I really don't know what should I pick up to address you with. How do you percolate the constitutional values in society, and particularly with students? The focus here has been on law students and law education, and I think what's your name, Mika, I think made a very relevant point, which, I mean, since she spoke about it, I mean, all credit to her, but I was wishing to address that. Which is that I think it has to be built from classrooms in school. I mean, going back in time again, I can only do that because the kind of subject that I had to learn was civics, which is government. You had parliament, you had state legislatures, you have a prime minister, you have chief minister, governors, very, very straightforward and superficial. But there was no understanding of what really a constitution is and what it means to the people and how it is meant to regulate society, regulate government, and as Professor Dan said, to control governments, to control institutions, and also ensure safeguards for the people. So that understanding was lacking till I came to it was more, for me, it was more of a political understanding. It was probably more individual because when I joined college, I was completely innocent of all this. I, let's say, almost breezed through the days of the turmoil of emergency, completely unaware of what was happening, deeply, blissfully reading newspapers which were fully censored. But therefore, when that stopped, and the opposition leaders came out, there was literally an awakening for me and then I was looking out for every public meeting of all those great leaders who came and spoke, and then the tumultuous election days when we went through what many of the journalists of that time and people of that time said, this is the second freedom. So that set me thinking, and then I, of course, turned to the law. I made my decision. And I was very fortunate. Even when I entered the law, I was completely innocent of what the Constitution is. Being a pure art student who had done only literature, I knew about some ideas, but I didn't know what the Indian Constitution said. For me, I was very fortunate because Minerva Mills was being argued in my very first term, in my very first semester, in August 1979. And I decided to enter the court because I had a fascination for the courts then. And the great Nani Palkhiwala argued, and that was I fell in love with the law, with the Constitution. I bought the Constitution the very next day. And then that winter I bought the Keshwananda Bharati, the entire volume, which I still have. The point is, awakening can happen at any time, and the sooner it happens, it's better. The sense that I get from whatever I have read is that schools are wary of schools, that is schools at a primary or a secondary level, perhaps are not very comfortable with the idea of letting the children know of their own freedoms and rights. I don't know why this is not there as part of our textbooks. We see a general idea of the Constitution, we see description of government's policies, etc. But the idea, but the thought of these are your rights, of the broad rights, freedom of speech, then that you can question governments, and then you have independent institutions, not just the courts. You have the Election Commission, which regulates, a wonderful body which regulates elections, and perhaps we are so better circumstance, much better circumstance than other democracies which are older. So these have to be somehow taught at different levels, so that there is an awareness. Once there is an awareness, I think then we have a more enriched citizenry. And it's not just about being aware of the law, but how informed you are as a citizen who can raise those questions, sometimes necessary, sometimes very uncomfortable, to those who govern you, and who can and you can bring them to ask them to account for what they do. We have this great revolution of information, and that led to the enactment of the Right to Information Act. So all these are part of that movement, and I think therefore our constitutional values have been enriched by certain amendments like the right to education, Article 21A, etc. So some of these, plus some of the other darker parts which we have experienced, I think each generation of students has to be informed in the briefest possible manner, but so that they are aware of it. I am quite encouraged because there are small books written by other authors, which may not be part of the curriculum. But I've come across people who have written with children as their audience. And I think this is a very relevant part, and I think we should also inculcate the idea of linking these freedoms with our history. Take the Jallianwala Bagh incident itself. Why did the Jallianwala Bagh incident occur? What was behind it? What were those people protesting against? It goes to the essence of our freedoms. Your right to liberty, personal liberty, to be judged by an independent, neutral body. And third is your right to speech, free speech, and right to hold an assembly. All these rights just get encapsulated in one incident. And if it is not just taught as a historical incident where so many people were massacred and it was one of the markers of our independence movement, but something deeper, I think we can resonate, that would resonate with the people, and perhaps link with the idea of what is constitutionalism and why we are where we are, and why those led to what we are today. I think that's very relevant. That's one point I wish to make. The second is, again, how do you inculcate constitutional values in legal education? The peculiar, let's say, one angle which I wish you to explore is how to go about the business of interpretation. Is it possible to adopt a constitutional prism to statutory interpretation, and not merely provisions of the Constitution or in areas of public law? After all, when you come to the first contact point for someone who is accused of a crime or offense is when he goes to the magistrate for a bail. So the most sacrosanct of our liberty, of our rights, is liberty, personal liberty. The value of bail, the value of a fair trial, the value of a speedy trial, the value of not being incarcerated for very long periods, how these are the essence of personal liberty. I think this has to be inculcated in every classroom where criminal law is taught. That, I mean, it's intuitive, but I think it needs to be stated in a couple of classes. Maybe some of these great judgments which have dealt with this. I mean, if we had to spend time in 2 or 3 constitutional bench judgments to cull out a principle that speedy trial is part of a right to life, I think it's necessary that it should be taught even in the classroom in a criminal law classroom. So, likewise, when we come to civil law, for instance, in contract, I just give one instance, and Professor Barua and other law professors would completely understand this. We have this judgment of Central Warehousing Corporation, where the idea of what is unconscionable contract, public policy, that which is contrary to public policy, general public policy. What is that general public policy? Those are essentially constitutional elements which have been in some sense horizontalized. The question of the case of unfair contracts, we have seen this in the context of unfair contractual terms by state entities. But we now enter the era where there is a retreat by the state. Now, how are law students and how are law teachers going to handle this kind of unfairness? Because ultimately you see that each of these areas is now part of regulation. So therefore, when you see a regulatory law, what are the essential elements of the Constitution which is distilled in them? The non-discriminatory principle, the principle which ensures that you share your risk. If you are a dominant entity or a monopoly, you share your resource in the most acceptable manner. So these controls are necessary for society, and that again stems from the Constitution. And lastly, as I said, not much study has happened about institutions, the institution of election commission, and how these free and fair elections, which we see as they are today, the humongous effort that this body undertakes, and if you contrast it with the times when I was a student, and I think Professor Menon will also remember, frequent countermanding of elections, and it distorted election results. Now those seem to have at least completely been minimized, if not completely eliminated. And now the role of the election commission during elections, it is virtually like a dictator. For that brief 2 or 3 for a month or so, its diktats operate throughout the law, throughout the country, and it is able to bring order, and even say which officials can be in the police and other parts of the administration have to be moved from one state to the other, which even the center in normal times cannot. So these are important when you teach election law, when you teach other branches of law. So I am able to see this now as a judge, as a lawyer. I had no idea. I could link some of these, but not the way I am able to do now. Or even in the field of private law, for instance, when you go in for an injunction against a newspaper, the value of freedom, free press, the value of free speech, when you want a pre-publication injunction, or it may be in the realm of intellectual property, which I am very fond of, speaking, the tremendous potential of constitutionalizing certain principles in these areas of private law. I think there needs to be some kind of thought about how to inculcate the constitutional prism, as I call it, in statutory interpretation. There's much to be said and I must reflect on what Professor Dan has said about open and the closed models. To me, what matters is that law students, law professors will prepare law students. But as Professor Dan says, law students, when they graduate, assume different roles. And duty lies on them to act in accordance and consonance with these constitutional principles. And those who choose the career of law, as lawyers, I would also place special responsibility on them, that you have been fortunate to graduate from whichever is your law school. It may be a private law school, it may be a national law school, it may be any other law university. But you belong to that class or cadre of informed citizenry. So as and when the occasion arises, you have a duty to give back to society what you have got from it. You are fortunate, you are aware of your rights. There could be people around you who are barely aware of their rights. And I'm not talking of the big rights that we usually are very fond of, defending. I'm talking of small things. People are not aware of what benefits they can get from the policies which the government, offers them. People are not aware how to, fill forms for getting certain, benefits and welfare. Maybe there is time which you can always choose. There is time when you can choose what kind of role you want to assign to yourself, having regard to the kind of education you have been privileged to enjoy, and later maybe having regard to the kind of exposure that you had in society, especially among those who are not as fortunate, and there are plenty of them around us. You will be perhaps more enriched, and the idea of constitutionalism really will percolate when you act on these things. I think beyond that, I don't wish to say anything. As I said, there's a lot to think about, not only from what Professor Dan said, but the entire debate that took place. And I'm very grateful that all of you chose me to be a part of this function. Thank you.
Thank you very much, Justice Bhat. I think your comments really infused what we started with, the idea of how we can connect certain questions which seem very abstract to our day-to-day lived experiences, whether as students or teachers, as citizens. We have shot over time, and we will end soon. Since right in the beginning of this, when Justice Bhat entered, he first came and he paid his respects to his teacher, and since this is about legal education, I would request Professor MP Singh, who is here with us, who's been our teacher for all of us, to just say a few words on what he has seen today and how we might take this forward. So Professor Singh, if you could address for just a brief while, or even from there I could get you a mic. Yes.
Yeah. It may be slightly different tone, and the changes that have taken place since I was a teacher at Delhi University, and subsequently creation of these 5-year law schools, that difference I have never digested. Even though I have been part of Jindal for some time, I'm not at the moment, but I realize that in no way this education is better than the kind of education we imparted at Delhi University to people like Professor Bhat, as he has just mentioned. Most of our Supreme Court and High Court judges at the moment are Delhi University product, not a single one from any law school, including the National Law School, which was created by Professor Menon, which I had great respect for Professor Menon and the way he created that institution. No doubt about it that brilliant people were brought to that school. and the brilliant people actually came for teaching also. But the kind of teachers which were there in Delhi University, you will never have in any of the law schools. Professor Tripathi, Professor Bakshi, Professor D.K. Singh, Rohtgi, many others, they were the kind of different people who were devoted and committed to education, legal education. I think that is something which has to be considered, thought over, because the kind of education which we are giving now, that only is available to certain privileged people. It can't be available to ordinary people like me, who studied at Merit College for my LLB and for LLM at Lucknow University, where the fee was meager, and that also, in my case, could be exempted half of the fee or something if I requested the university that I am incapable of paying that fees. But whether it happens in Jindal or it happens in this Munjal Law School, I don't know. Thank you very much for being here.
Well, thank you, Professor Singh, and I think Philip spoke about this, about the access to legal education and plurality, very important. I think we have run out of time, so I'm not going to propose a formal vote of thanks, but a vote of thanks to our panelists here, those who are on our dais, Chair, Justice Ravindra Bhat, Professor Sham Menon, our speaker, Professor Dann, for finding time for the busy schedule, and I think making this lecture a very invigorating one. I think it will give us a lot of encouragement to scale it up and to continue this series as a list of public lectures on constitutional values and constitutional cultures. So thank you very much to the audience for coming, and thank you again, panelists. We have tea and light refreshments outside to continue the conversation, so please do join us for tea outside.
I agree, this kind of civic education should start